The first attribution model that allows you to accurately measure when a viewer sees your ad on TV and the actions they take afterward, from site visits to conversions. Here's how it works. A viewer sees your mounting commercial. We note their IP address, device IDs, and additional signals, then identify all devices tied to that household. If the viewer visits your site on one of those devices within a time window that you define, that's a verified visit. When the viewer converts on your site using one of those devices, we can attribute that outcome to your CTV campaign.
Hi, besties. It's Katie from Without a Crystal Ball. Now, this video might not be that exciting for you, but I thought it was interesting because Ryan Reynolds' company, Mountain Inc., MNTN Inc., the same company that his organization Maximum Effort was divested from when they were being sued by Mr. Baldoni, and that got dismissed. And MNTN claimed that they were going to sell back Maximum Effort, but Mr. Reynolds was going to stay on their board as a key member of their company. And it just looked like on paper, they were trying to cover their butts because of the possible liability of Ryan's lawsuit at the time that Baldoni had filed against him, right? And his behavior with the failed marketing campaign. Well, that company is being sued, and it's being sued in a big way by a company called Intent IQ. And this company, Intent IQ, has been suing all kinds of advertising and marketing companies, including Meta, Amazon, LinkedIn, Microsoft, really any platform that uses a tracking system to track ads online and manage those, because Intent IQ owns patents and a system that is the foundation for how all ads are tracked online. And the company has been very lucrative as they've been targeting these different companies. In some cases with these lawsuits, they have been having companies completely shut down. Others have been forced to pay massive judgments, like Amazon. So they were awarded $122 million against Amazon. And it was targeting Amazon because they were running cross-device campaigns based on consumer profiles. They were actually seeking $348 million from them, but they got 122. They've also sued Amazon, AWS, Microsoft, LinkedIn, Xandr, Laudame, Roku, Comcast Freewheel, Viant, Live Intent, to name a few. They make so much money on litigation, it's even more than they make on patents, according to their lawyer. They have licenses which were acquired by other companies when they were sued. So Meta, Microsoft, Roku, Samsung, and Freewheel all license their patent to use it for their advertising. Okay. So there's a couple options here. You can either license with them and pay them a licensing fee, or you can ignore their patent and you can get sued, and then your entire system can get shut down. But the patent itself is foundational for how the entire online advertising industry works. And it's foundational in IP ownership over the blocks that are used to track IPs. So I shared a video for you in the very beginning because the company that Ryan's in Mountain, they claim that they are the ones that developed this breakthrough method of tracking IPs, but they're not. It's fraudulent. What they're doing is no different than every other ad company. They track your IPs, but this is not their patent. The patent is actually owned by Intent IQ, according to a lawsuit filed against them. And this lawsuit was filed on May 23rd, one day after the company went public. So the company has been suing all these other companies on the tech market. Other companies are taking credit for their patent, and this company owns 80 patents, and they are willing to defend against all of them. And many of them are foundational for a company that claims to be able to track your revenue and how your ads track. And it's directly related to TV ads. So this is not the first time that Mountain has been sued for intellectual theft or patent infringement. They have settled other cases, but this one is pretty major. because it could effectively shut down their company. And what's interesting is that this lawsuit was filed on the 23rd of May, a day after the IPO went public. And yes, they just this week, they released their Q2 earnings reports, their first earnings to the public, to investors, and they made no mention of the litigation. And legally, they are supposed to let investors know if the lawsuit could impact the total revenue of, like, if it's more than 10% of the amount of money that their revenue is or their assets are. And in this case, this is seeking that they stop using the platform that they market to their consumers, Mountain, as their invention. It's the entire system that Mountain uses. It's their basis of their company. So if they're prohibited from using it again and barred from it, it could destroy the whole company. So without going into too much detail, they're using a patent that is being they say they are willfully using this patent without any they're willfully infringing on this, they're claiming, okay? And they say it's being used on their performance TV, audience targeting, attribution, verified visits, and their integration and flexible APIs, which are all under the doctrine of equivalence, and they're one or more method claims of the 398 patent. So they have these two separate patents that they're suing on. Despite defendants' knowledge, they write, of or willful blindness of the 398 patent, or at least as a result of filing and service of this complaint, defendants continued and still continue to infringe on the patent. In doing so, defendant knew or should have known that their conduct amounted to infringement of the patent. Accordingly, they are liable for willful infringement. So since this lawsuit has been filed and they've been notified of the suit, they're being told that they're still using this product. They're still selling this as their own. They're still infringing, and they're not doing anything to stop it. They attached a bunch of documents to show just how close the plagiarism is in the marketing between the patent that was developed by Intent IQ and what Ryan's company is doing. And they say that their infringing activities have injured or will continue to injure the plaintiff unless the court enters an injunction prohibiting further infringement of their patent, specifically enjoining further manufacture, use, sale, importation, or offers of sale that come with the scope of the patent claims. The entire way that they sell what they can do for their consumers, Mountain, are based on this patent. So if they receive a permanent injunction, it could truly impact their entire company because this is how they sell their products. This is what they use, and they're claiming it's their own. And then there's a second one that they're claiming that they use, which is again for their accused instrumentalities, which is what they use for their TV audience targeting, attribution, verified visits, and integrations of flexible APIs. And they say it's basically down to almost the word of what their patent says. And they're seeking, again, another injunction that they stop using this. So what they are asking the court for is a judgment in favor of the plaintiff as it has infringed the asserted patents, either literally or under the doctrine of equivalence, a judgment in favor of the plaintiff finding post-suit willful infringement of the asserted patents, a permanent judgment prohibiting defendant from further acts of infringement, a judgment and order requiring them to pay plaintiff its damages, costs, expenses, and pre-judgment and post-judgment interest, a judgment and order requiring the defendant to provide an accounting and to pay supplemental damages to plaintiff, including without limitation pre-judgment and post-judgment interest, a judgment and order finding that this is an exceptional case within the meaning of 35 USC 285 and awarding them a reasonable attorney's fees and any other relief as deemed necessary under these circumstances. And they're asking for a jury trial, okay? So Intent IQ has been winning these cases all over because of what their patent is and what they own, okay? And as I stated, Ryan's company is claiming that this is their invention. And this is so shady because they haven't, to this day, told their investors about this. The media is completely ignoring it. And they haven't responded to the lawsuit yet. And they won't be until this week or next week. They keep getting extensions of time and they brought in new attorneys this week. And it was just awarded that they get an extension. I think they have to respond to the lawsuit in like 10 days. But when they filed this Q2 report for their investors just this week, they didn't say anything about this lawsuit. So currently, investors are kind of ignorant about this, which is a little bit of a big deal here. But they have a map that shows the acclaim that's in the patent they own and how MNTN is directly infringing. And it says a method implemented using programmed hardware computer system, the method comprising. And then theirs says, Mountain says, a method implemented using a programmed hardware computer system, which includes, and it says receiving at the computer system. This is again, intense. Receiving at the computer system an electronic identifier of the first device, and then MNTN Mountain writes receives at the computer system electronic identifier at the first device, and then Mountain adds their own spin on it and a bunch of information here to make it look like they've come up with this. And so they add all of this, this is why we're unique. This is what we've done. These are our inventions. The next one is Intense patent says with the computer system automatically generating and storing electronic indicia of an association between the first device identifier and an electronic identifier of a second device based on automatically recognizing that each of the first and second devices was connected independently of the other to a common local area network, wherein the computer system is connected to the local area network through the internet, but is not in the local network. And then they show how Mountain's promotion of this says the exact same thing. Now, some of this is basic in how systems find each other, but this company has the patent for the basics, and they're claiming Mountain that what they're doing is unique to them. And it's like, as you go through again, this is intent, with the computer system based on the electronic of the association between the first and second device identifiers, sending electronic transmissions that causes another programmed hardware computer system to take action based on the first profile associated with the first device, blah, 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 blah. And then you see that it says the exact same thing, almost word for word by Mountain. And then they put in, for example, and again, they add their spin on it. So they're taking something that's not unique, that everybody uses, and they're claiming it as their own. And the patent happens to be owned by Intent IQ. And they provided an entire list of what the patent is, how it works, and then they use it for the same thing for the 962. And this happens to do with the programmed hardware computer. And what they've done is it would be almost impossible for them, at least in my opinion, to say that they had no idea that this patent existed, because they're lifting almost word for word what the patent says, and then they're just adding their own example at the end to make it look unique to them. So they notified them of this theft in May. And generally, before a lawsuit is filed, you get notified that a lawsuit is coming. And some companies are trying to fight back and stop these lawsuits, like Meta. They're trying to fight back and say, well, no, these are just like the patents. These claims shouldn't be patentable because they're the obvious process to the industry. Establishing obviousness is a term of art in patent law, meaning a professional in the field would be expected to know the process or technology. So the fight from the other people that are using the same method are saying, well, this is just how these system works, so they shouldn't be able to get a patent for it. But a lot of these companies are paying them to license, and other companies are not. And then they have judgments and injunctions set up, and they can no longer market that this is the system and how they track advertising. I think, and I'm not sure how it works, but the way that Mountain is advertising it, it's like they have found a revolutionary way to track advertising and IP, and it's just not. It's not revolutionary at all. And to make this clear, this week they put together a investors meeting for their Q2, and it says leading senior management team. And Ryan Reynolds is number 4 next to George Dewey, who is the chief brand officer, and Ryan is the chief creative officer. So there's no confusion that this is a patent infringement or a theft of a patent being sold and marketed as their own invention to get customers to use their product and believe that they are getting something that other companies do not offer. And the way that this lawsuit reads, it sounds like this will impact a wide variety because in their investors document that they just released, they said that they had a proprietary tech stack enabling advertisers to launch performance TV campaigns for the first time. This lawsuit would impact matching audiences, which is called audience attribution or audience targeting. Basically, it's finding the target audience based on how this patent works and how the technology works. It also would impact their measurements and attribution, conversions of performance, campaign performance, and third and first party data, transporting, reporting down to order ID. So that would be affected. And then automated optimization as well. So it impacts audience targeting, performance TV, attribution, verified visits, and integration and flexible APIs. And they're really selling this as their own software. Like they've created this, they're the ones that own it. It's really wild that if this is true and if they end up having to like get this injunction or they just pay a licensing fee, you would think there would be due diligence on the head of the company that they know what they're selling isn't their own. Like there's nothing groundbreaking about what they're doing, but they're saying that it is. So Ryan has a history of being involved in products where he has stolen intellectual property, allegedly. Well, he was accused of the theft of the Deadpool movie from Tim Miller. Blake and Ryan are accused of trying to steal the movie It Ends With Us from Justin Baldoni and the sequel. Mountain is now being accused of patent theft here. Mint Mobile has been sued in the past for infringement on how their networks are set up. Mint Mobile has also been currently being sued in a class action for illegally recording calls. But here, this is a big lawsuit because if they don't settle and they don't pay a licensing fee and they go to court and the court says that you need to stop and cease what you're doing, it impacts the entire way that they track their product and their marketing and their advertising across the internet. So what they're telling the consumer is, listen, we can help you create the marketing. That part is, sure. No one has a patent on creating an ad, right? But for them to be able to track it to make sure the consumer is getting what they need and that they can track that the purchase is coming directly from the ad so that, they get paid as the marketing agency, they'd have to find an entirely different system, which would mean they'd have to promote their company in a completely different way. It breaks down their company at the core. And really what it exposes here is that, at least as according to this lawsuit, what's alleged here is that nothing that they're offering is unique. In fact, it's somebody else's idea repackaged as their own. Does that sound familiar? So another lawsuit, another alleged allegation of patent theft, infringement, and another fraudulent tie to Ryan Reynolds. We'll have to see how Mountain responds. But other companies have been sued and you've seen what's happened. So tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.